Westman. I'm the Executive Staff Articles Editor of the Kansas Journal of Law and Public Policy, and I'm excited to introduce our next two speakers. So to my far left is Alan Rupe. He's the Managing Partner of Luke's Brisbois, the Wichita and Kansas City offices. He's a board-certified trial specialist, certified by the National Board of Trial Advocacy, and a member of the American Board of Trial Advocacy. He received a BA from KU and a JD from Washburn University, which we forgive him for. He is the Vice Chair of Luke's Brisbois' National Employment Group and a frequent presenter on the topics of employment, civil rights, and education law to attorneys and clients throughout the country. And to my immediate left is Annie Calvert, an associate in the Wichita office of Luke's Brisbois and a member of the Labor and Employment Group. She received both her BA and JD from the University of Kansas, and she was a publication editor of our beloved journal. So please welcome our next group. Thank you.
You going to start? You want me to?
Okay.
All right. We put together this presentation, The Future of Work, Employment Lawyers Inbox in 2050. When I was asked to talk about the future of employment law, I immediately asked Annie if she would come along and help. I was born in 1950, so in 2050, I'll look at my inbox when I'm 100 years old. And what I want to talk about to begin with, let's get to the great quote first. Maybe not. That'll work. So the power of the lawyer is the uncertainty of the law, and that's going to be the message throughout this, is that there are unpredictable factors and variables. If you don't think that doesn't happen every day, you haven't checked your 401k today. There are all sorts of factors that affect not only life but the practice of law. What I want to do is set a pair of bookends for you. I was born in 1950. I graduated from KU in 1972. In law school in 1975. I started practicing in 1975, and there have been enormous changes since my early career. I was able in 1975 to practice law, in fact tried a case before I took the bar because they had provisional admission after you graduated from law school before you finished the bar exam. Those things have changed. Carbon paper taught me how to do as close to perfect work when I wrote as you could possibly imagine. That is a gift that not everybody had. I didn't mean to look at you. That's not a gift that everybody who is used to texting has. Carbon paper, for those of you that don't know, carbon paper was a piece of paper that if you pressed down on it, it made an impression on the paper below. So when you put together a letter, and some of you may not know what that is, but when you put together a letter, you would type on the original, and it would make a copy through the carbon paper. And my first secretary's name was Nancy, and Nancy played absolute hell on me if she had to retype what I had written because I looked at it and decided I wanted to change it. So I learned the technique of being very accurate first time out with carbon paper. Court reporting has changed. The first court reporter I heard in front of Judge Wolfsleigel out in western Kansas. He had a pencil that unraveled as he took down shorthand what was said in the courtroom. And those days have changed. Just as a footnote, if Russ Walker, that court reporter, laid down his pencil, then he knew that the judge was about to unload on the lawyer talking. And that happened more than once. And that pencil became pretty much a sign of how things were going in the hearing that I was in front of. Today, when I take a deposition, I don't use it at trial, but when I take a deposition, I use the real time, where the court reporter's notes are instantly in front of me, and I can repeat the question, especially when somebody tries to evade the answer. Time, trials, and privileges have changed. First time, as mentioned earlier, but when, in 1975, when you would write a letter, you would be able to think about it, give it some thought before you reduced it to paper, and then the response to that letter usually took 2 or 3 days, and then you could think about the reply, and you had considerable time to think about it. Time is extremely compressed. And what used to be, even with a fax machine, you had some time to think. That time today is instantaneous. And I say with clients, there's a 7-second rule. That if a client emails you with a question, you better be getting back to them instantly. Because if you don't, they'll move on and find something else and talk to somebody else about it. The other thing that has really changed is trials. I was fortunate enough to, when I started practicing law with an insurance defense firm, I handled a bunch of criminal appointment cases and a lot of soft tissue injury cases and we tried cases all the time. Those opportunities for lawyers today are much fewer between. The number of trials we have per year is now 1 or 2, and I think my most trials of the year was like 1985, 1986, and I tried like 50 trials, and it was all the same cases, all soft tissue injury, claims changed, but it was all the same kind of thing. Those opportunities are good. The privilege issue is changed considerably because of technology. The notion of privacy, I think we lost about 1989, 1990, and some people have just realized it. But the fact is that in terms of attorney-client communication or work product privilege, those privileges have shrunk considerably. And the practice of law now is much more transparent in everything than it was when I first started practicing law. One last point on the changes. In employment law, when I started, it was before the EEOC announced the EEOC guidelines on sex harassment. I can remember waiting for those to come out in the early 1980s. Employment law has changed considerably. And what started out early, just as the Title VII started, was local laws that were fragmented. Different places had different types of employment laws, and we saw the federalization of employment law as Title VII and the case law developed. And at some point recently, I think, and we're going to talk about it, the laws that were once federal are becoming, turning watch back at maybe 1975 soon, because the fragmentation of federal law is becoming localized. So you have a smorgasbord of local employment laws that you're going to have to deal with between now and 2050. Just a final note with regard to the period of time we're talking about. One thing that hasn't changed since 1972 when I was a kid, I have been a moderate Republican my entire life. And in 1972 on this campus, I was known as a friggin' liberal, or a friggin' conservative, because I was a moderate Republican. And everybody was far more liberal than I was, and I was at the very right end. I have not moved a centimeter. And I will tell you, in Sedgwick County anyway, in 2020, I feel like, and I'm treated like I'm some sort of liberal. And the politics have not changed one bit. I think politics and the change in politics are going to affect employment law between now and 2050 in a huge way. But those are the bookends we're working with. Let's start in on topics that deal specifically with employment law in our inbox in the future.
So looking towards the future, we see two big areas. Obviously, it's impossible to predict what's going to be happening in 30 years, but two areas that we see really emerging are the use of artificial intelligence in human resources departments, helping with hiring, promotion practices, etc., and the rise of the gig economy, Uber, Lyft, Etsy, all these kind of independent contractor employee debates, and how that's going to shape employment laws and how it's going to fragment them across local and state governments in the future. So, let's get to work tomorrow. So here's an example of an email that we might get in 2050. Alan will be 100 reading this in his love. He suggested maybe it should come to me, but I said no, he'll still be practicing when he's 100. So, it says, good morning, Alan.
I did look at my 401k, I'll be there.
It says, good morning, Alan. Our company's been approached by an AI firm who wants us to use their HR software, helping us in screening applicants, assisting with our decisions on who gets promoted and who gets terminated, that kind of thing. What are the potential risks, potential benefits of using this kind of software? So a lot of our business is not just litigating employment issues, but counseling employers. And this is going to be huge in the future. The costs and the risks and the benefits of using this kind of software are really complex, and it's a really interesting topic to dive into. So we're excited to talk about it today. So obviously this is a really challenging use of AI because so much of human resources is based on human judgment, human connection, talking with your employees, and the kind of personal interview process. A lot of people are really entrenched in that. A really good example of a kind of a startup using this was Amazon. In 2015 was developing this AI software to help them screen applicants and to help them assist in their hiring process. Now, part of this was, putting data points that they want to see in new employees, but another part was adding data from the past 10 years of applicants and hiring decisions. And because the past 10 years of hiring decisions and applicants were majority male, the system learned to prefer male candidates. It downgraded applicants that used phrases like women's club, women's association, and promoted applicants that said things like, I executed this, or I captured this amount of X. And so it was never implemented company-wide because they discovered these serious gender problems in their AI software, but it's a learning technology And we're by no means technology experts. I want to make that very clear at the beginning. So,
We did that when we couldn't start.
yeah, that's fair. That's fair. So we'll talk about AI generally and not get into too much of the technical aspect, but more about how the law is going to react to this use of AI in HR.
In the keynote speech, there was this discussion, and it was really interesting because and it was in the context of criminal law in a sense, but the notion of, I don't think AI is the correct term. I think the better term is learned intelligence, because the computer is learning from somebody what factors to look at. And as mentioned with regard to implicit bias, the implicit bias of whoever inputs the program in the computer to do the selection, that implicit bias works through the learned intelligence to filter the same way that employment law, look at people who are decision makers and what filters they use in terms of decision.
So not only am I not a technology person, I'm also not a math person. So I think when you solve math problems, you have variables and things like that, right? And so when you're looking at it and translating an employment problem into a problem that a computer can solve, you have to look for those target variables that are observable characteristics in employees that the computer can search for and can find. So if Amazon said we need a new employee in the shipping department, or more likely in the tech department, for an abstract concept like good employee, the programmers and the people that are helping develop these programs have to make subjective decisions about what makes a good employee and how to label those examples for the program so that it can easily identify them. And employers generally value things like intelligence, productivity, detail and action oriented, and that can be, that data can be gathered by past performance, it can be gathered by resume, keywords, but it also takes into account employees that have been successful in the past. And as we've talked about already today and already in this presentation, what's been successful in the past includes a lot of bias, includes a lot of discrimination, includes a lot of issues that are going to be a problem when you're looking to hire an employee that it seems like it would be a more fair system because it's all computers and you're seemingly removing human bias, but it's actually kind of the opposite. It's just learning to include that bias in the hiring process. So that brings us to Title VII. And this is kind of the framework that we're going to be working with when we talk about how you challenge the use of AI in the legal system.
So let's lay the 1964 Civil Rights Act over the issue of artificial intelligence and talk about Title VII. Just a brief 101 course. Title VII in 1964, great stories on how that came to pass, but the end result was that it was a piece of legislation that prevented discrimination on the basis of race, color, religion, gender, national origin, age, FMLA, disability, all came later. The basis of almost every Title VII claim is either a disparate treatment kind of case or a disparate impact kind of case. And let me give you examples of each. Probably, 98% of the cases that we deal with are disparate treatment cases. And those are cases in which somebody said, I was treated differently because of my protected class. I received adverse treatment because of my protected class. And that may be somebody different origin, different color, any kind of protected category. And those are all cases in which you look at the treatment compared to others, and it's disparate treatment. And if the adverse job action is taken because of that protected category, it's decided that it was discrimination. What is the other side of the other type of case that we get into occasionally is a disparate impact case. And that case is a case in which the, we change the slide yet? Let's go to the next slide. The disparate impact analysis seems to be ideally suited for the artificial intelligence. And here's the deal on disparate impact. Disparate impact starts with a facially neutral policy that isn't pointed at disparate treatment one way or the other. Just the announced policy appears to be neutral. But as a statistical matter, or as a matter of practice, the neutral policy has an adverse impact on a protected category. These are cases in which experts are frequent, and the analysis is what kind of impact does this neutral policy have on the decision. So a couple of examples. There are a number of disparate impact cases dealing with African American males and beards, and the requirement that they be clean shaven and the resulting skin condition that occurs as a result of shaving, often for African American males. Height in the airline industry. It was, for a period of time, there were height requirements that you had to be so tall. And that had an adverse impact on females. And those kinds of cases started to evolve. The key case is Griggs versus Duke Power. And in that case, the court held that Duke Power couldn't require applicants to have a high school diploma or pass scores or a written test unless those requirements had a demonstrable relationship to successful performance. That's where the disparate impact cases began, was in that decision. Probably in the employment context today, the most frequent filed disparate impact case is with regard to arrest records and conviction records in job applications. You may have heard the phrase "ban the box," and there is an effort to eliminate those questions dealing with arrest and conviction from employment applications. Just a Kansas footnote on banning the box. One of the things that has just kind of amazed me is the political movement. In big red states like Kansas, like our neighboring Oklahoma, I always said Kansas was the biggest red state I'd ever been in. And I said that to a friend of mine in Oklahoma City, and he reminded me that in presidential elections the last couple of times in Oklahoma, there has not been one precinct that went Democratic. And of course, we've got Douglas County and Kansas, so Oklahoma is bigger and redder than we are. But in terms of banning the box, those states have made a real effort to reduce the conviction rate and to excuse folks who have been convicted for nonviolent crimes. And Mark Holden, who general counsel for Coke Industries, has gone on a national campaign on behalf of Coke to advocate that. And if you think about it, it's completely consistent with the libertarian point of view. And they have linked up with others to really make some impact into the banning the box movement. But those are disparate impact cases. Those questions, when asked, have a disparate impact on certain minorities. And so disparate impact and AI now have come together, or will come together,
prima facie case showing for a disparate impact case, plaintiffs have to prove through statistical comparisons and a lot of statistical data analysis that the challenged practice or the selection device that the employer is using has a substantial adverse impact on a protected group. And that the defendant can always criticize the analysis or provide other statistics and data to kind of combat that, but that's the plaintiff's burden at the beginning, is to, through statistical comparisons, show that there is an adverse impact. But it's not just that the disparities exist in the statistics, they also have to show that the observed disparities were not caused by innocuous or unavoidable factors associated with external forces. So it's a pretty big burden on plaintiffs at the beginning to be able to compile all that data and to be able to show that there was disparate impact, at least at the prima facie level.
And that prima facie case can be affected in the defense way by simply showing that the criteria was job-related and business-related and necessary. And here's the rub, and where the law is not clear with regard to artificial intelligence. The courts don't seem yet to be willing to wade in to how the sausage is made in terms of what the artificial intelligence is when it's put together. So that implicit bias that we've talked about, or the programming of that computer with the prejudices of the people that are doing development, nobody has yet waded into that area. And the courts seem to be satisfied to say, hey, that's the program, it's dictated by business necessity, end of the case. And I think at some point, somebody like the comment we heard this morning, where they start raising the notion that that implicit bias is built in to the development, and that has a disparate impact on minorities in the decision making. Somebody really creative is going to come up with an argument to the courts that push that theory into our judicial system. It's not there yet.
So as I said before, the plaintiffs are going to face pretty big challenges applying this disparate impact analysis to an AI software. They would need access to the algorithms, they would need the training data and the data collection methods, and they're going to run into a lot of intellectual property arguments, like we heard at the keynote speaker in the criminal sector. They've run into that before in cases. So that's going to start happening in the employment context as well. And we're also going to have issues with confidentiality with employee records. If you're trying to get all the data that they've put into this system to select a new employee, all the data from past employees might be privileged as well. So there's going to be a lot of issues for plaintiffs trying to figure out exactly how and where the discrimination occurred within that AI software and within the algorithm. And it's really expensive and burdensome to identify that issue. In order to rebut the prima facie case, as Alan said earlier, the employer just has to show that the practice is a business necessity. It's job related for the position in question and consistent with the business necessity. So in the Griggs case, they had a high school diploma requirement or a written test requirement. But the court didn't find that either of those were really relevant to the actual job that the person and the applicant was going to be doing. So in order to show in AI that the software that you're using to screen applicants is a business necessity, it's going to be pretty easy for employers. AI is predictive in nature, and so you're just going to say, look, clearly this software is picking out things that ideally suit this person to this position. Its entire purpose is to predict the qualities of this person are job related. So that's going to be a pretty low burden for defendants in the future if we stick with this same disparate impact framework to show that, well, clearly this software is a business necessity. Look at the applicants it's spitting out are clearly ideally suited to this position, and it must be by nature of the data and by nature of the algorithm.
The notion of employer bearing costs, I don't think it's going to go anywhere. It tends to shift burden of proof, and my doubts are that that's going to happen. The interesting part of this, the next slide, is the bottom line defense. And that is, I think, ultimately, if the employer can show that minorities are hired or promoted at a higher rate than majorities, regardless of how that sausage is made, the bottom line defense is going to be paraded. The notion of disparate impact case in hiring based on AI, as indicated, has not been fully developed. But I think we ought to keep it in mind. And keep your eye on banning box, because there are now some suggestions, and we're sorting through the reasons for it, but there's some suggestions that when you do ban box, it actually has a worse impact on hiring minorities. And I think the notion behind that is that I'm going to use this phrase, and it's probably not accurate, but it makes the point. When there was discrimination, it was all confined to people with conviction. And now, without the box, the opportunity to expand the discrimination to old notions of stereotyping occurs. And as the data comes out with jurisdictions that have banned the box, it may be that some employers can raise the bottom line defense because the impact of banning the box may have exactly the opposite effect of what it was intended.
And one more point about the bottom line defense. If it does come back, and if it's challenged again, and if the court allows it in the future, there's going to be so many challenges about how to implement it. Is it a percentage of the labor market proportionally to the people that are available for that position? Is it going to be completely equal? Is it going to be you have to promote more minority than the majority? That's going to be a source of thousands of legal challenges. So that's going to be really interesting to see how that plays out, and we're excited to work on it in 2050.
Let's jump to the next email, if we can.
So here's another email that we might receive in 2050. Alan Howell as well. This maze of new local laws is dragging me down. I had a moon trip scheduled for next week, but I'm going to have to cancel. We're sued under that screw new law in Kansas, provides overtime pay for Lyft drivers. Can you help? Now, we don't know if there's going to be Lyft drivers in 2050. There might be automated cars that just take us, but for the sake of argument, let's say that Lyft is still a thing. In the gig economy, which is a labor market characterized by short-term contracts. You've got things like Lyft and Uber, you've got Turo, where you can rent your car to strangers, handymen come to your house, a dog walking app. There's endless amounts of innovation and new types of jobs that are coming out, and more people, especially millennials, are using the gig economy as their full-time income.
And remember, uncertainty is the path into the future. And the gig economy has obviously some pros: efficiency, transparency, freedom for workers, utilization of idle resources and labor, creates substantial legal risk. The cons are uncertainty, privacy, lack of benefit, and creates substantial legal risk. Here's what we think, and uncertainty is the key. Here's what we think is going to happen. And I'll focus on California for a minute. As the gig economy evolves and the federal system does not step in or relies on what's been before, as interpreted by jurisprudence among the federal courts, you're going to see more and more local laws adopted to dictate the pros and the cons with regard to the gig economy. And I think it's going to cause the kind of fragmentation in employment law that I saw way back in 1975. You're going to have just a whole smorgasbord of different laws that apply, and those laws will reflect the politics of the local community. So keep your eye on California.
And one example of this coming out of the woodwork right now is the contractor versus employee debate. Gig workers right now are generally independent contractors. States like California are trying to make Uber and Lyft drivers employees instead, which would enable them to have access to benefits, collective bargaining rights, unemployment and workers' compensation benefits, a whole slew of things that employees get, and that makes it beneficial to be an employee. But as more people enter that gig economy and don't have access to those things, we're going to start to see a reshifting of what it means to be an employee, what it means to be an independent contractor, and what it means to be able to have access to those rights.
And what we see, and it was my own coincidence, but I stepped out during the last session because I had a conference call on a independent contractor versus employee driver case that we're defending in California. And what is happening in California right now is indicative, I think, of what we're going to experience locally across the country in different places. The tension, the argument is between the drivers who in California are claiming they are employees, and therefore they should be entitled to overtime in excess of 8 hours a day. They should be entitled to overtime in excess of 40 in a work week, meal breaks, rest breaks, mandatory lunch breaks, those types of claims. On the one hand, employee versus, on the other hand, independent contractors. Independent contractors would not be subject to all the California employment laws, and they would be considered to be their own employees. So those things, laundry list of things I mentioned would not apply to an independent contractor. And it all depends on what test you look at to determine whether they're an independent contractor or employee. So the IRS test, the one the Department of Labor uses for the Fair Labor Standards Act, is the economic realities test. And we have the elements listed there, but the essence of those are that these are, it's an entrepreneurial arrangement where the quote alleged employee is actually a business that has the opportunities that are outlined in this PowerPoint to create the entrepreneurial business and make a profit. And that's the essence of the economic realities test. What California has been focusing on is the ABC test. And it focuses not so much on the entrepreneurial notion, but on who's actually controlling the circumstances of that job. And it looks more to elements, as we've described in the PowerPoint, that deal with control. And that's the fight we're going to see in the future. And what's going to happen is, depending on the politics of the local governments, they might very well adopt the kind of law that California has adopted, indicating that this is all essentially, even though it's called independent contractor, they're really employees because of the control, and therefore all the penalties and overtime pay should be paid because of this.
So the gig economy is super diverse. It takes a different skill set to be successful on Etsy than it does to be on Uber. Same with Airbnb and TaskRabbit. You can choose to work part-time, you can choose to work full-time, and this freedom and this diversity of talent and skills and sophistication level, there are apps where you can become a freelance programmer and do programming and IT for companies. And it's just going to be really difficult for employers to navigate how they're treating these independent contractors, how many hours they're working, and responding to the way that these people are treated under the law. Some notable examples of laws that have been reacting to this in the past is Airbnb in New York. They threatened to fine every single host unless they were present. They spent $8 million countering a similar law in San Francisco in 2015. Sometimes they require drivers to pay additional insurance. Some states want to designate them as contractors, and some states want to designate them as employees, and that's largely due to the politics of that state, as Alan mentioned. This is going to be an interesting topic, especially as we go forward with plans like Medicare for All. That could alleviate some of these burdens that people are facing, but again, it's just going to take time, and the law is reactive and not proactive in general, and so it's going to be interesting to see how technology progresses, whether there's even Lyft drivers and Uber drivers in the future, and how those people are treated. A notable example of this fragmentation is in Seattle. They passed this ordinance in 2015 that allowed Uber drivers and Lyft drivers to collectively bargain as independent contractors. Instead of trying to classify them as employees, they said, no, you can maintain your independent contractor status, but we're going to give you collective bargaining rights and allow you to unionize. This was challenged by the Chamber of Commerce on both antitrust and preemption grounds for price fixing, and they said it was preempted by the National Labor Relations Act because the NLRA gives employees the right to unionize and to collectively bargain. And they said that it was intentionally left out and therefore preempted by Congress when it was passed. And after some challenges, the Ninth Circuit affirmed the district court that it was not preempted by the NLRA and that independent contractors could collectively bargain. The antitrust issue was remanded for to decide whether the price fixing violated antitrust rules. And the city of Seattle kind of adjusted in the middle of that antitrust fight their tactics, and they removed the driver earnings as a part of the collective bargaining issue from the ordinance, and so that issue kind of went away on its own.
So as we move to 2050, keep your eye on local law, because I think that's going to explode. We're seeing it with regard to independent contractor employees. You're beginning to see it with regard to ban the box. You're seeing it in minimum wage and those issues. As the federal government becomes less involved, I think the local governments are going to become more involved. And what happens with that into the future is it's going to be bumpy, because we don't know with any certainty what's going to happen where. And the notion of lawyers being local, living next to the courthouse, may be the way of the future, as opposed to a national firm with a national practice, because local laws are going to, I think, become much more hot topic. It's also going to be Trump, because if you are local in how you apply employment laws, it's going to be an entirely different ballgame depending on where you are. And politics, I could have said politics as opposed to Trump, but bump Trump sounded. But in terms of the politics of employment law, that's going to be something that the future in the practice of law you're going to have to deal with. 1 minute over. Should we do it again just to see if we can do it under? Questions?
Sorry to interrupt. I thought there was a pause, and I thought there was a chance to sneak in a joke. Is he still going to be president in 2050? So sorry about that. The serious question is this, that a few years ago we were looking at the Uber and Lyft cases, and are these people independent contractors or employees? So thank you for this briefing. I can now use it when teaching. Thank you very much. Here's the test I want a reality test. Are there some states where certain agencies within certain states are saying that there's a variation on the economic realities test, where if somebody's making a majority of their income from one employer, the state agency can say that you're effectively an employee of Uber because the majority of your income is coming from Uber.
That's actually one of the elements in both tests. So in the economic realities test, if you're only working for one, that's a factor that weighs in favor of employee, and the same with fees.
Now, the question, what we were chatting about, and then we had to move on and write about other things, does that mean that an employer could set up a gig platform, and then unbeknownst to the employer, oh, somebody's not working for anybody else. I didn't even know that this person's making the majority of their income from my platform. I mean, this is kind of a possibility in all of these scenarios. That surprise you have employees that you didn't realize.
Economic realities test would look at what the policy is. Do they allow people to work for somebody else, whether or not they actually do it or not? The ABC test looks at the actual application of that on whether they do or not. When I defend these cases, the first thing we go out and do is start, especially, and it's going to sound unethical, but it isn't, under 4.2, if it's a putative class, if you're anywhere except Pennsylvania, you can go out and actually talk to the class members who may at some later point be represented by counsel. You can talk to them, and getting a good sense from visiting with the drivers on what the actual practice is with regard to whether they have their own business established, are they their own corporation? Does the side of their truck say does it say Lyft or Uber or whatever, or does it have their own company name on it? Do they have any other employees? And get a sense for whether they're entrepreneurial, running their own business, or whether they're really just independent contractor name only, being run by a singular company.
Thank you again.
With that, I'd like to thank Alan, Rupe, and Calvert for their time. If you guys still have questions, we can continue this conversation. I'd like to invite all of you to lunch right now upstairs in the Rice Room, and we'll reconvene in exactly an hour.